This course is titled An Introduction to English Contract Law. The learning outcomes of this course are to teach you how to apply the law in relation to contracts in England, to teach you how to identify the main elements of a legally binding contract, and to teach you how to assess which contracts are, or are not, legally binding. First of all, I shall explain a little bit about the significance of contracts in society. Contracts play such an important role in society that there are very few things that you can see around you that was not made or sold as part of a contract. The average person may enter into a contract on a daily basis with or without their knowledge. In fact, each time you purchase goods or services from another person or party, an agreement is formed. In a typical scenario, a party agrees to pay a certain price in return for the supply of goods or services provided by another party. However, not all agreements are regarded as legally binding under the law. By legally binding, we mean that where there is a dispute between the parties to the contract, the party claiming that the other contractual party has not upheld their part of the bargain may bring a civil action before the courts to claim damages for breach of contract. The question of whether or not a contract is legally binding under the law ultimately depends on a judgment made by the courts. The courts rely on the law of contract to arrive at their conclusions, by applying the relevant law to the individual facts in a case to determine if the particulars of the case satisfy the law relating to the formation of contracts. During this lecture, we shall therefore discuss what the law says in relation to the formation of a legally binding contract. The formation of contracts. The legal scholar Triatel defined a contract as an agreement giving rise to obligations which are enforced or recognized by law. The factor which distinguishes contractual from other legal obligations is that they are based on the agreement of the contracting parties. Therefore, it is clear from this definition that a contract means that the parties have willingly entered into an agreement. Despite this, parties often enter into agreements without knowing all of the rights and obligations flowing from the contract. By examining the main elements of a contract, we shall get a better understanding of what components must be included in a contract for it to be binding. There are 5 main elements of a contract. These elements include 1. Offer. 2. Acceptance. 3. Consideration. 4. Intention to create legal relations. 5. And, finally, capacity. The first 3 elements, offer, acceptance, and consideration, are the main elements of a contract. We shall be taking a look at the law relating to each of the 5 issues separately. We shall first take a look at the law relating to an offer.